Morning.
In the restroom.
We'll come back to it.
Thank you.
(2023) CR 103, State versus Billy Russell Tomlinson.
I'm attorney for Mr. Tomlinson. He is unfortunately incarcerated in Coffee County, and been serving some time there. I've heard maybe out of. Going to ask if we could reset this. Some other things going on with the case too, but that's the big one.
The state doesn't oppose resetting it, Your Honor. It's also, I think, the constitutionality of the homeowners improvement fraud statute is on appeal. Is that right?
Is it my case?
I don't.
No. I had one, but it got appealed. I did a bench trial on
Oh,
it.
your case is being appealed. I don't know.
My case got already heard, and the Court of Criminal Appeals said that they defined that even though I found the defendant guilty of this violation, they found that it was not, in fact, a violation. It was a civil matter, so they vacated my decision. So I don't like bench trials. So you want to set this for December the 8th?
Just so we can track it, Your Honor.
Oh, December 8th.
Thank
you. Ms. Pascal, are you ready on Jessica Watson?
Yes, Your Honor. So the very last court date that I was present was July 28th. At that time, I announced to Judge Combo that we would be resetting today for a VOP hearing. My client had just been picked up in Montgomery County and she was not here. So I am requesting the violation probation hearing today.
Are you ready on the violation of probation hearing?
We can, Your Honor. She needs to speak that. Mr. Potter's here.
Just, I'm not prepared today. Just for arraignment.
Well, it is for arraignment, and typically what would happen, unless there's an agreement to resolve the case, we would just simply set it for the next VOP, which is next month. So
I did have an agreement with DA with all to reset today for VOP hearing. So, I mean, I did have that agreement. We announced it to the court. So I would prefer to move on today.
Mr. Potter's not ready, Your Honor. I'm gonna.
I'm not, Ms. Pascal, I'm not disputing what you understood your agreement was, but the docket entry shows that the defendant was not present and that you were here and announced that the defendant was in the Montgomery County Jail and requested to reset and transport. And then Judge Turnbow reset it for today to issue a transport order.
Yes, Your Honor. That's
so based on the fact that this is only here for arraignment according to our court records, not disputing that you had that agreement, I'm going to reset it for next month. What is your next date?
Your Honor, due to that, my client may want to switch admits as to what she needs to do today. So
Well, talk to her and let me know, but what the next court date would be for a VOP. September 8th would be your next date, a little less than 30 days away. So talk to your client, and depending on what she wants to do, we'll either give her that date or come back to her. So, thank you. Are there any second calls that we can take care of?
If I may, Your Honor.
All right. This is on the superseding indictment arraignment.
Yes, I believe there's a.
Here you go, Doug.
Yes, Your Honor. We would waive formal reading of that, enter a plea of not guilty.
Plea not guilty is entered. It does not show that this was a superseding indictment, so it don't show that there was a trial date already. Is that correct?
And there is a co-defendant that we have not been able to locate. not even citizens of the country, but to get investigator Etheridge, senior, Dad Etheridge on that. And we just asked for another status date for 12/8.
All right, we'll set it for December the 8th,
Thank you, Your Honor.
2025.
That's all the business I have today. With the rest of the day.
All right, thank you. Clemens,
Your Honor, on page 4, we have the case of Gayla Rice, Mr. Rice, is the case of Mr. David Bell. This case was standing in today. Oh, wanted to add that.
okay. We'll set it for December the 8th. That'll be the last status date that we'll give. It'll either be resolved on that date or set for trial.
Your Honor, just for the record, I do believe we have it resolved, but Mr. Walker now works for the state, so that's gonna have to be an issue that.
He now works for the state.
Prosecutor in
Okay.
Easton. So I think we might have to do something.
All right. Okay. We'll set it December 8th. And all right, we've gone through the docket and we'll take a recess this morning and allow anything else that we need to get any of the other inmates brought over that we're ready for. Because I think everybody else on the docket is an inmate. I need to check on the attorney status as well for that. All right.
All right, let's talk about that. This hearing with Judge David D. Wolfe was less about fireworks and more about the delicate choreography of docket management, attorney readiness, and making sure every piece fits into the larger calendar. From the start, Judge Wolfe's demeanor was steady and pragmatic. He handled scheduling conflicts, transportation orders, and questions about appeals with a calm patience, but he wasn't shy about drawing a firm line when needed. For instance, when counsel pressed to proceed with a violation of probation hearing despite the state not being ready, Wolfe leaned back on the record, noting that the official docket reflected the matter as an arraignment only. His approach here was classic Wolfe, courteous acknowledgement of the attorney's understanding, but ultimately siding with the written record and maintaining order by resetting the matter. That's the kind of judicial steadiness that keeps a crowded docket from turning into chaos. The defendants themselves didn't take center stage so much as their situations. Billy Russell Tomlinson's attorney requested a reset due to his client's incarceration in Coffee County, and Judge Wolfe obliged without fuss. It was telling that Wolfe even shared a quick anecdote about a prior bench trial he handled that was overturned on appellant honest. Almost humorous aside that revealed both his depth of experience and his human side. Jessica Watson's case, meanwhile, showed the tension between defense counsel eager to move forward and the prosecution not yet ready. Wolfe's choice to hit pause rather than press ahead reflected his careful balance of fairness and procedure, ensuring no one could later claim they were blindsided. Even when attorneys sparred lightly over whether there had been an agreement, he de-escalated with quiet authority and a reset date. On the attorney front, it was a mixed bag. Defense counsel came in prepared with requests, arguments, and even reminders of prior understandings with the DA. But readiness is a two-way street, and Wolfe made clear that without alignment, the hearing would not be forced forward. You could almost see the chess game happening live, defense eager to resolve, prosecution cautious, and the judge sitting squarely as referee. No one looked ill-prepared in terms of professionalism, but some moments of not ready yet gave the impression of loose ends that Wolfe had to tie up. Witnesses and outside participants didn't play much of a role this time. This was more about case management than testimony, Overall, the atmosphere was calm with occasional flickers of tension, but never tipping into disorder. Judge Wolfe's ability to keep the room on track, even while acknowledging attorneys' frustrations, spoke volumes about his style. He was firm but not harsh, willing to listen but insistent on order, and importantly, he never lost sight of the bigger picture, making sure cases move along fairly and on the record. It might not have been the most dramatic hearing, but it was a textbook example of how procedural clarity and a judge's even hand prevent unnecessary detours. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.